Hello everybody, welcome to ixamBee's Legalbee. This is Amrita, your law faculty here at ixamBee. Embrace the ixamBee learning experience with us and download our app for 50% faster job preparation. You're at the right place if you're preparing for any government job or competitive exams after completing your law or while pursuing your law as well. If you're preparing for any exam, ixamBee provides you coaching for various examinations. You can check the online courses available on www.ixamBee.com. आप इन courses के demo activate करके देख सकते हैं. If you have any queries, you can reach out to us by writing us an email on hello@ixamBee.com or call us on the number 9205524028. You can also write to us in the comment section of the video. Today I will be continuing with the series that I have started of 300 important MCQs for IBPS SO Law Officer and UIIC Legal Exam 2024 preparation. आज के वीडियो में हम लोग डिस्कस करने वाले हैं questions which are relevant for your banking exam, which is IBPS SO Law Officer examination. The topic is from banking laws and a very important subject, that is SARFAESI Act. Asset reconstruction company shall not commence or carry on the business of securitization or asset reconstruction without obtaining a certificate of registration granted by the RBI, having net own funds of less than 2 crore rupees or such other high amount as the RBI may specify, having net own funds of not less than 2 crore rupees or such other higher amount as the RBI may specify. Both A and C. Now here there are slight differences in the options. जैसे कि ऑप्शन B और C में आपको समझने के लिए अगर वीडियो पॉज करना है तो आप पॉज भी कर सकते हैं, and you can also download this PPT with you. You can keep a record of all the questions that I am discussing in this series with yourself. So the correct answer over here is answer E, that is both A and C. A is obtaining a certificate of registration granted by the RBI, and C is having net own funds not less than, that means minimum 2 crore rupees or such other higher amount as the RBI may specify. This is covered under section 3, registration of asset reconstruction companies. Central government will set up a central registry for the purpose of registration of transactions of securitization and reconstruction of financial assets and creation of security interest, registration of the transaction of securitization or reconstruction of financial assets and creation of security interest, granting the certificate of registration to carry on business of securitization or asset reconstruction, all of the above, both A and C. So what is the purpose of setting up a central registry by the central government? Correct answer is A, registration of transaction of securitization, reconstruction of financial assets and creation of security interest. This is covered under section 20, which talks about central registry. And कौन establish करता है ये भी आपको पूछा जा सकता है. So central government establishes it. Under SARFAESI Act, an aggrieved person has now a right to refer the matter to DRT and then to the Appellate tribunal by depositing -% of the claimed amount. यानी कि अपील करते वक्त अग्रीव पर्सन को कितना परसेंटेज ऑफ डिपॉजिट करना पड़ता है, यानी कि जो क्लेम्ड अमाउंट है उसका कितना परसेंट उसने डिपॉजिट करना है विथ while you are going for appeal. 100%, 75%, 25%, 50%, 35%. It is a very important question, very much expected. Correct answer is D. 50% of the amount has to be deposited. After Supreme Court decision in Mardiya case, and its fallout on the very intention of legislation as well, importance for recovery and preventing long legal battles basically has paved way for such kind of provision. So the amendment stipulates payment of 50% amount instead of 75%. Actually जब एक्ट आया था तब अमाउंट 75% पे था. The SARFAESI Act gave birth to which of the following? Securitization company, reconstruction company, asset construction company, asset reconstruction company, asset management company. Very easy this is. Correct answer is D, asset reconstruction company, ARCs. These are the specialized agencies which facilitate bad loan resolution of a banking system. Which of the following is appellate tribunal under SARFAESI Act? Debts Recovery Appellate Tribunal, Securities Appellate Tribunal, National Company Law Appellate Tribunal, Recovery of Debts due to Banks and Financial Institution Appellate Tribunal? None of the above. This is also a very simple question. Correct answer is A, Debt Recovery Appellate Tribunal. DRAT is specially established. Appellate Tribunal means Debt Recovery Appellate Tribunal, which is established under Section A, Clause 1 of the Recovery of Debts due to Banks and Financial Institutions Act. Asset Reconstruction Company may perform other functions as are laid down under Section 10 of the Act, and it does not include act as a manager where no pecuniary liability arises, acting as an agent for any bank or financial institution, acting as a receiver if appointed by any court or tribunal, acting for the settlement of dues payable by the borrower. All of the above. So asset reconstruction company क्या perform कर सकती है functions? ये section 10 में दिया हुआ है. Out of all these options, which of the following function is not included has been asked. So be very clear with the functions of asset reconstruction company. काफी important है. यहाँ पे correct answer होगा D. It does not act for the settlement of dues which are payable by the borrower. Section 10, other functions of asset reconstruction company, in which this point is not covered. No secured creditor shall be entitled to exercise the rights of enforcement of securities under Chapter 3 of the Act unless the security interest created in its favor by the borrower has been registered with the RBI, has been registered with the Central Registry, has been registered with the central government, has been registered with the competent authorities, all of the above. No secured creditor shall be entitled to exercise the rights of enforcement as per Chapter 3 unless that security interest created in its favor by the borrower has been registered with the Central Registry. That is option B is correct. Section 26D talks about right of enforcement of securities. Amended provision है ये. What are the circumstances under which the RBI may cancel the certificate of registration granted to an asset reconstruction company? Ceases to receive or hold any investment from a qualified buyer. Ceases to carry on business of securitization or asset reconstruction. Fail to comply with any conditions subject to which the certificate of registration has been granted. All of the above. Either of the above. So what are the circumstances under which RBI may cancel the certificate of registration? Correct answer is E. Either of the above will be correct. Section 4 deals with cancellation of the certificate of registration. When did Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, ये full form भी आप लोग जरूर याद रखिएगा. SARFAESI का पूरा full form है ये. When did it come into force? Direct question, knowledge based. अगर आपको पता है तो आप definitely जल्दी आंसर कर सकते हैं. And ये एक्ट के लिए आप पता कर लें तो ज्यादा अच्छा रहेगा. It is important. Enactment as well as enforcement. Correct answer is 21st June 2002. Transfer of applications pending before two or more debt recovery tribunals may be filed by an asset reconstruction company before SAT, DRAT, NCLAT, High Court, Special Court. So the applications can be transferred if it is pending before two or more DRTs. So it may be filed by an asset reconstruction company for transfer purposes before whom? Correct answer is DRAT, of course the Appellate Tribunal. Section 5A covers this point. Correct option is B. Appeal can only be entertained by the Appellate Tribunal only if the borrower has deposited with the Appellate Tribunal the amount as specified under the Act. However, the Appellate Tribunal may, for the reasons to be recorded in writing, reduce such amount to less than 25% of the debt, not less than 25% of the debt, more than 25% of the debt, such amount as the RBI may specify in this behalf. None of the above. यानी कि ऐसा कोई रिडक्शन नहीं होगा. ये क्वेश्चन हमने पहले डिस्कस किया है कि कितना परसेंट अमाउंट डिपॉजिट करना पड़ता है. तो उस अमाउंट में कितना रिड्यूस हो सकता है फॉर रीजंस रिकॉर्डेड इन राइटिंग? करेक्ट आंसर इज बी, नॉट लेस देन 25% ऑफ द डेट. 25 से कम तो आप कर ही नहीं सकते. सेक्शन 18 डील्स विद अपील टू अपीलेट ट्रिब्यूनल. इन दैट इट इज मेंशन्ड. Which of the following method of asset reconstruction is not defined under SARFAESI Act? Takeover of management of business of borrower, absolving the liability of borrower, lease of a part of business of borrower, enforcement of security interest, none of the above. So इसमें से कौन सा method of asset reconstruction defined नहीं है SARFAESI Act में? Correct answer is B. Absolve the liability of borrower. Section 9 of SARFAESI Act deals with the measures for asset reconstruction. Definitely, absolving the liability of a borrower cannot be mentioned over here. This is also actually something which you can answer based on your common application of logic as well. Who among the following deals with the cases of recovery of debts above rupees 10 lakh due to the banks and financial institutions? DRT, NCLAT, NCLT, DRAT, Civil Court. Cases of recovery of debts above rupees 10 lakh if they are due with the bank and financial institutions will be filed before DRT. Very important question again. Dash is an asset or account of a borrower classified by a bank or financial institution as substandard, doubtful or a loss asset in accordance with the directions or under guidelines relating to asset classification that is issued by the Reserve Bank. NPA, bad asset, doubtful debt, non-effective asset, dead account. इस तरीके के asset या account को क्या कहा जाता है? Very simple. Correct answer is NPA. Non-performing asset is an asset or account of a borrower which is classified as above by a bank or financial institution if it is coming in that criteria. Then guidelines have been issued by RBI and it is known as NPA account. Last question for today. When a bank or financial institution lends money against security, who will be the originator? Bank, borrower, obligor, secured creditor, none of the above. So इसमें से originator कौन कहलाएगा अगर bank or financial institution money lend करता है against some security? Correct answer is A. Again very simple. Options may confuse you, but the answer is very simple. Originator is the owner of a financial asset, and here in this case, bank is so, and it is a secured interest as well. For more such kind of videos, stay tuned with ixamBee and Legalbee. Don't forget to subscribe our YouTube channel. Prepare 50% faster with us and download our app and check all the features available on the app as well. Thank you, everybody.